Evicting a tenant can seem like a complicated process, but in this video, we'll quickly explain the eviction laws in Connecticut and outline some simple steps landlords can take to initiate an eviction. We're eForms, the largest online database of fillable legal forms, and in this video, we'll talk about what the eviction process looks like, Connecticut laws that determine how evictions are handled, and how to legally remove a non-compliant tenant from a property. Be sure to watch to the end of this video to find a link to a fillable eviction notice. First, what is an eviction? An eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks on a property or physically remove a tenant from that property, even if the tenant breached a lease agreement. If the tenant refuses to leave after violating the terms of a lease agreement, a landlord must seek an eviction from the court. Eviction is different from the simple termination of a lease. A landlord can opt not to renew a lease after the specified term has ended. There is no need to involve a court in this process. A landlord can only evict a tenant for reasons allowable per state law. In Connecticut, these reasons include failure to pay rent and failure to comply with the terms of a lease agreement. In the state of Connecticut, there is a 9-day grace period in the case of failing to pay rent on time. If the tenant still hasn't paid after 9 days, then the landlord can issue what's known as a 3-day notice to quit, also known as a Form JD-HM7. This is a letter that instructs the tenant to either pay or move out within 3 days. If, however, the tenant has breached the terms of the lease in some way unrelated to the payment of rent, then the landlord will issue a 15-day notice to quit. This document instructs the tenant to fix the issue in question or otherwise move out within 15 days. If the issue is irreparable, for example, if the tenant has found the property being used for criminal purposes, then the tenant must move out immediately. The 3-day and the 15-day notices to quit shouldn't be confused with the 30-day notice to quit, which essentially ends a month-to-month tenancy. This document gives a tenant 30 days notice that the lease will be terminated. In the state of Connecticut, a notice to quit has to be served by a process server. If the tenant doesn't respond or doesn't rectify the specified problem, then the landlord can file an action in the housing section of the Connecticut Superior Court in the county where the property is located. The landlord must file 3 forms and pay the filing fee of $175 in order to bring the action. The first form is known as a summons. This is a form that tells the tenant that they are being sued for possession of the property. The second is called a complaint. This document indicates the reason for which the tenant is being sued. The third is a copy of the notice to quit. This must be accompanied by a return of service or a document confirming that the documents were properly served on the tenant by a professional server. Once all documents have been filed, the court clerk will set a hearing date. 4 days before that date, the landlord must have copies of all of the filed documents delivered to the tenant by a process server. If the tenant doesn't respond formally before the hearing, the landlord can file a motion for a judgment. At the hearing, a judge will decide whether or not the tenant can be forced to leave the property. If the court approves an eviction, a sheriff can authorize to remove the tenant and the tenant's possessions from the premises. We've got everything you need for eviction proceedings in Connecticut, from eviction notices to court documents, and you can access all of them at the link below.